Hello there and welcome once again to In Your Corner. I am John Scholes. It is 1-833 In Your Corner to reach out or inyourcorner.ca alongside, of course, every week, Sivan Tumarkin and James. How are you, Mr. Fireman?
I can't complain, John.
Good, beauty. We got a lot of stuff to get through today, guys, including the 3 signs that the insurance company may be about to deny your LTD claim. We'll tell you what to do and how that works. That is coming up here in just a bit. Some emails, some phone calls. It is a show that is chock full of goodness, but we always start, guys, with a little background of why we're doing this show, what you guys both do, and then we'll move on to a story I know you have to tell, Sivan.
Sure. There's really 3 reasons I think that we're doing this show. Number 1 is so that our viewers will understand their rights. This is something that we see day in and day out. People come to us and they just don't have an understanding of how the disability process works. And so understanding what your rights are is an excellent first step and something that is absolutely necessary and unfortunately sorely lacking. The second reason is if we're doing our jobs well, what we'll be able to do is help people to prolong the period that they are receiving benefits if they are already approved for their benefits. And that obviously is very useful because if they're on disability, that's the only source of income. So as much as possible, we want people to be entitled and receive their benefits for a longer period of time. And the third reason is in almost every case, eventually people are going to get cut off or denied, and we want to make sure that their case is as good as possible when that happens, so that when it's time to challenge the insurance company for the denial or for the termination of benefits, they're in the best position possible.
What do you think?
Yeah, no, I agree completely. I want to make sure people understand that we deal specifically with long-term disability claims. We don't deal with workers' compensation claims, but we do deal with injury claims and long-term disability. And let me tell you, John, we've been helping for quite a few years people, not only in Ontario, but across BC as well. And let me tell you about this one lady that had contacted me last week. Her name is Carol. She's from Surrey in BC. She's 42 years old. She's a mother of 4. And she was an executive at a marketing company, and she had breast cancer a number of years ago, and then it was in remission, and then it came back. And she's receiving chemotherapy and a whole bunch of other drugs. And so she had initially gotten short-term disability, and then she was on long-term disability for about a year. And what happened there is the long-term disability insurer got one of their doctors, who's not an oncologist, their doctor, just a general practitioner, to do a paper review. So that doctor never even saw her. Just did the paper review, reviewed the medical documentation that was provided, and concluded that because she was getting these treatments and she was doing somewhat better, that she should be able to go back to work. And of course, the insurance company relies on that and says to her, you have until June of this year to go back to work. That's when we're going to cut you off. And of course, she's panicking. Her oncologist and her family doctor are saying absolutely no way. She's nowhere near ready to go back. And she doesn't know what to do. Her family doesn't know what to do, her husband. And I spoke with both of them. And I told them, you know what? It's a good thing that you contacted us now. Because, most people, when they're on long-term disability, John, they are told in advance that there are going to be cut-off payments at some point down the road. Don't wait for that point. Do exactly what Carol did here. She contacted us. We're going to be able to now deal with the insurance company. We take, from a legal terminology standpoint, we take this as anticipatory breach. We're saying that the insurance company, by saying that they're going to cut her off when they should not in the future, they are telling our client that they're going to breach that contract. They've effectively breached that contract by saying that. And what does that mean? It means that we can help her right now, and we may be able to actually get a resolution with the insurance company before the money stops coming into their bank account. And that is the ideal situation. Because the worst thing in the world for them right now is not only for them to deal with the chemotherapy, the drugs, and this terrible disease, but having absolutely no income and no ability to pay for the mortgage and for the kids' activities and everything else that comes with it.
In any case, though, you wind up getting it resolved much sooner than you would if you're waiting until you're actually getting cut off. If you wait until you're actually cut off, until the benefit starts, there's almost nothing that we can do to get your benefits reinstated that day. It's not going to happen.
Right.
There is a process, and we do it pretty quickly, but it still does take some time. The sooner you get started on it, the sooner it gets resolved. So it doesn't pay to wait.
It just baffles me, especially in this situation. I mean, it's one thing if the insurance company at least physically had their doctor, not an oncologist, their general practitioner, see this client of yours, but There's no contact. It's a paper trail. How do they expect that to even hold water if it ever went to court?
That happens a lot. That happens a lot. And you know what? They're not expecting this to necessarily work in court. They're expecting you to think that they have the upper hand and for you to simply walk away. And the reality is that many people actually do walk away because they don't understand their rights. They don't understand that you can stand up to the insurance company. Now, one thing that I forgot to mention here, which I should mention, is that as they were speaking with me, they also mentioned that they were in the process of appealing that decision.
Oh boy.
You don't do that. You don't appeal these long-term disability denials and cutoffs. Those appeals, in my opinion, are useless exercises. They end up, they deny these appeals, they prolong the process, and sometimes because of these appeals, of you appealing one time, second time, third time, you may even get to a point where you are beyond that limitation period. There's a 2-year limitation period for starting a legal claim, which is exactly what we would do to put the squeeze on the insurance company, to press on them, to push on them, to come to the table to negotiate a fair resolution of the claim. So don't waste your time with appeals, and that's exactly what Carol and her husband did correctly in contacting us, and now we advise them, and they know what the next steps are, and they know that there's going to be a resolution.
InYourCorner.ca is a great place to go to find out more information. While you're there, you can find out where you can catch the In Your Corner radio show, which we do. Your partner, Lior, of course, host of the Employment Hour and Employment Hour and 30 here on TV as well. We get a lot of phone calls on that show, and because there's a lot of cross-pollination between disability and employment, we get a lot of phone calls on that show that have to do with what you do. So we're going to play one back, and I know you guys want to comment on it.
3 years ago, I had some procedures on my back. During that time that I was off for my back, I was told that I didn't meet the requirements for permanent disability or disability benefits anymore. So they cut my benefits off and told me I had to show up for work or I would be terminated from employment.
There you go.
So what I found particularly interesting is that he was told that he's going to have to return to work or face termination. The fact that he was told is important here because it's a pressure tactic. A lot of times insurance companies will take a position over the phone that's designed to make you feel like you don't have any control, like you have to do whatever they say, but they'll avoid putting it in writing because they know they can't say or can't go as far as they're suggesting. And so one thing that we tell all of our clients to do, and certainly this is a useful exercise for anybody who's applying for long-term disability or who is on claim. You want to make sure there is a paper trail of every conversation, every contact that you have with your insurance company, with the adjuster, or anyone else who contacts you from them. And sometimes the only way to do that is to make sure that every time they call you on the phone, that you stop what you're doing and say, sorry, hold on for just a moment. I want to get some paper and a pen. I want to make sure I write this down. Take notes. Ask them to stop if you need time, but take detailed notes of everything that's said. And as soon as that conversation is over, you email back that conversation, the summary of the conversation, just the substance of what was said, so that there is a record of it.
Nice.
And if they're going to dispute what was said in that conversation, they better do it right then and there, because no one's going to buy it if 3 months down the road or a year down the road they're saying, oh no, I never said that. Well, you got the email the same day. If you had a problem with it, you should have said something then. No one's going to buy it down the road. And so when you do that, it sends a signal to the insurance company that, oh, wait a minute, we're being recorded here, we're being watched, we better be careful. And a lot of times that's going to be sufficient to get them to back off. So that's the first thing I want to say. You really have to point out where there are pressure tactics there. And, you know, so it's just something that you can do to put yourself in a better position. I know Sivan wanted to comment on this about the employment part of it, so I'll let you cut in here.
Thanks. I think it's important to understand that many people who are disabled and dealing with long-term disability also face pressure from their employers. Sometimes those are small mom and pop employers, small shops. Sometimes you're dealing with major institutions, banks even. And a lot of these companies, they don't understand what their obligations are to the employee, which is what you and Lior talk about on the Employment Hour in 30. And what's important to understand is that we have at our firm a mix of disability lawyers and employment lawyers. And just this past week, we actually had a seminar for all the lawyers talking about the interplay. And there's so many issues that cross over between employment and disability. So if you are a disabled employee and now you're getting pressure from your employer, they're telling you, we're going to let you go, you know what, we can help you with that, because they can't do that. That's a breach of the Human Rights Code, for example, to let a disabled employee go. They can't do that. And what happens when you're let go? You're entitled to severance. But if you get severance, let's say you go to a firm that only does employment law, and you got severance, well, guess what? Your long-term disability insurer will likely be able to get credit for that severance. So how can we massage that settlement? How can we negotiate something with the employer that puts more money in your pocket? So that's very important to understand, that because we do both disability law and employment law, we're able to maximize the amount of money that our clients end up getting at the end of the day.
And I think what James said moments ago is very important as well, and that is document everything.
Yes.
That goes for everything in life, but especially with this and with employment too. Document, like literally document everything and have it confirmed.
Yeah, even by notes. I mean,
Yeah.
just make yourself notes. It's extremely, extremely important, and that gives us, the arsenal we need down the road to challenge the insurance company saying, no, you said this or you said that. No, I did not. I have records. I have emails. I have letters. I have faxes.
And I sent them to you.
Absolutely.
Yeah.
And so that allows us to then really, give it to the insurance company, so to speak, right? I mean, we need as much as possible, as much as you give us, to push back on the insurance company, to force them to come to the table to negotiate a fair resolution of your claim.
3 signs that your insurance company may be about to deny your LTD claim. That is on the way. You want to reach out anytime. 1-833 in your corner and inyourcorner.ca. In Your Corner continues. Stick around.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-833 in your corner, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to In Your Corner. To reach out, help at inyourcorner.ca or simply inyourcorner.ca online to catch past shows on podcast and some other information there as well. Want to get into this, our topic for the day, the points made by you guys or by me. You guys are going to answer to them. The 3 signs the insurance company may be about to deny your LTD claim. This is a very common occurrence. Number 1, guys, they've asked you to attend an assessment with one of their doctors or I know you love this word, consultants. Yeah. James.
So this is a good sign that they're going to be cutting you off in the very near future. And the way you can tell, when they're sending you to see a doctor, especially a doctor, they're paying money out of pocket for that. That costs them money. And insurance companies are not looking for ways to spend more money. So if they're doing that, you have to figure that they're doing that for a very specific reason. And the reason is almost always going to be because they want to see if they can cut you off. And if they get anything in that report from the doctor or from the consultant that helps them to justify cutting off your benefits or denying your claim, they're going to use it. When they spend money out of pocket, you can bet they're just looking for something.
Is it? I want to move on to the next one, but we've talked about that for years on In Your Corner, and it just seems like, you know what? It's almost like that doctor they're sending you to see that the insurance company is paying for. Aren't they kind of expected to come up with something?
Sure. I mean, I don't want to say in every case, and there are situations, especially when you're dealing with the most serious claims, with the most severe injuries, where they're going to be more cautious. They'll send them to someone who is indeed actually independent. But for the vast majority of the claims, they have a roster of doctors that they use on a very regular basis. Now, I very much doubt that anyone is so foolish as to send a memo with expectations laid out on what they're supposed to find, especially on a particular file. But if you're a doctor and you know that you're getting 60% or 80% or 90% of your business from this one source, and you've got a pretty good idea what they want to hear, if you're not saying that on a fairly regular basis, you can bet that they're just going to go find somebody else. Right. So, even if someone is being, very straightforward and honest in their assessments, they're not going to come up very often because they're just not going to get used. Right. The insurance companies are going to wind up using the doctors that are giving them the opinions that they want.
3 signs your insurance company may be about to deny your LTD claim. Number 2, Sivan, they've suggested that you should maybe start a gradual return to work program.
Well, you know, that sounds a little odd if your own doctors are saying that you're not ready to go back to work, and if you know you're not ready to go back to work. But as soon as they start suggesting that, they're essentially queuing you up. They're telling you that they think that they don't believe that you are disabled enough from going back to work. And sometimes they would do that after sending you to an assessment. In fact, that happens quite often. In many instances, they will do it in or around the 2-year mark after you've been on long-term disability for about 1.5 to 2 years, close to 2 years. And the reason is because then the eligibility test for LTD changes, right? The first 2 years, the test is, or the criteria is, can you do your own occupation? Beyond the 2-year mark, you have to show that you can't do any occupation for which you're suited for by training, education, or experience. And as soon as they start hinting, and it may not be at the 2-year mark, it may be after 6 months, as soon as they start hinting to you that maybe you should start considering going back to work, your antennas should be going up.
Your spidey sense should go off.
It
right?
should go up, which means that if you haven't done this already, you should be confirming all verbal conversations by email.
Right.
You should make sure that your doctors continue to state in the reports that you're still unable to go back to work. Everything has to be documented. And as long as you do that, we have what we need in order to challenge them if they in fact take the position that you are ready to go back to work and you know you're not, and your doctors know you're not. So just don't assume that if they tell you you should go back to work or you're going to get cut off, don't assume that that's how it is. We can challenge that so long as your doctors are on side with you and your doctors are saying you are not yet ready to go back.
By the way, it's 1-833 in your corner to reach out through phone or inyourcorner.ca. We were talking about the top 3 signs that your insurance company may be getting ready to deny your LTD claim. This one is a pure scare tactic, and they've suggested that they've checked your social media posts or they've conducted surveillance on you. So watch out, we're looking at you, right?
Well, I'll go back to the first point here. If they're conducting surveillance, what that invariably means, that's right, they've hired an investigator to follow you around and to videotape you when you don't know they're there, or take pictures, do some digging online, figure out what you do on a day-to-day basis, so on and so forth. That costs them money.
Yep.
They're spending money out of pocket. You can bet they're looking for a way to cut you off. And they will use anything they see in there as a way to try and justify denying your claim or cutting you off. And you see it all the time. But the other part of that, I think, is really important for our viewers to understand the impact of social media. So as a best practice, you want to make sure that you are using the privacy settings on any social media account that you have. So you want to make sure that the only people that are able to view your social media profiles, whether it's Facebook or Instagram or whatever, that the only people that can view those are the people that you know, that you're friends with, that you give permission to. And just as importantly, the only people that can post on your social media accounts are ones that you have approved. So if someone wants to post something on your Facebook wall, for example, you would get a notice saying this person wishes to post something, do you approve of it? And you can view it first. And then just use common sense. Take a look at it objectively. If this is posted on my wall, does that make me look bad?
Right.
And if it does, don't put it up there. It's all common sense. On the other hand, if your insurance company has somehow gotten photographs from your profile or what have you, they're going to try and use that as a way of saying, oh, you're okay, you're not really suffering the way that you say that you are. Now, of course, there are some instances where they may well be correct. If you're claiming that you have a physical injury that keeps you in bed and they have a video of you at the local gym training for 3 hours a day, well, that's a problem.
Yeah, tough to explain.
But it's usually not that clear cut, and especially when you're talking about mental health claims. When you're talking about mental health claims, you may be suffering from depression, but that doesn't mean that every waking hour of your life you've got a frown on your face. That's just not the reality.
On the contrary,
and we know that now. We understand that. As a society, we get that. And so if your insurance company goes in your social media profile and takes a picture of you at a family occasion, or maybe at someone's wedding or what have you, and you happen to be smiling, and they try and use that against you and say, clearly you're okay, you're out in the world, you're enjoying yourself, therefore you can go back to work. No, that's not the case at all. And if that were to go to court, and that's the evidence that they're relying on to support their claim, as opposed to a thorough assessment from a qualified psychiatrist or other doctor, they're going to be in a lot of trouble because no one's going to buy it. Judge isn't going to hear that.
And I think at this day and age, we all know that social media is generally full of shiny, happy people. These are the highlights of your life. It's not necessarily the bad stuff. That's what people post.
Absolutely. Right? That's well understood. That it's not a secret. You know, if you look at someone's social media profile, I think at this point people understand that whatever you see there doesn't give an accurate reflection of this person's life. It may show you some of the things that they are doing, but that doesn't show you all of the things that they're doing. And there's an awful lot that isn't captured by social media.
It is help@inyourcorner.ca to send over an email anytime during the show or otherwise. We'll get to one from Andrew. Andrew says, my wife suffers from an autoimmune disease, arthritis, osteoporosis, depression, and chronic fatigue. Her doctors all agree that she can't work, yet the insurance company says that she won't go on long-term disability because she doesn't have enough medical documentation. Here we go again. Is there a point in appealing this decision? The appeal is underlined. She already gets CPP disability.
There's absolutely no point in appealing that, and insurance companies routinely tell people that they don't have enough medical documentation to support the disability, the definition of total disability under the policy. And so when people look at that, they think, okay, well, maybe my doctors haven't written what they're supposed to. Maybe I'm simply not disabled enough, but I know that I am because, you know, I can't get out of bed or whatever it is. And, you know, Andrew's situation here, his wife's situation, is extremely common, and we speak with people on a daily basis, again, across Ontario, across BC, where they don't understand where the insurance company is coming from. And of course, when they get that denial letter, at the end of the denial letter, there is a very formal paragraph that says, you may appeal this decision and give us more documentation. And there's zero reason to appeal those denials. Something to consider here is that Andrew's wife is getting CPP disability. To get CPP disability, you have to show that your disability is fairly serious and prolonged. It's a very difficult test to meet. That doesn't mean that if you don't meet that test, then you're not disabled. I'm just saying that the fact that Andrew's wife already qualifies for CPP disability tells me that the insurance company, in my mind at least, just on the face of it, is 100% wrong. Clearly, they've produced enough medical documentation to prove that she is disabled. In this case, I would be comfortable telling Andrew that we could resolve his wife's claim fairly quickly. We would get the insurance company to the table. And, you know, we've had situations, John, where people have come to us and they've seen other lawyers. They've spoken to other lawyers, and other lawyers have said, you know, because of this surveillance, we don't think we can help you. Because of this reason that the insurance company gave you, we don't think we can help you. And so people they don't know what to do. They simply assume they walk away until someone tells them about us or about the show. And we look at everything, and we look at every document that's presented, and we look at the surveillance if there is any. And you know, we often find that so many things have been missed by these prior lawyers who've looked at these cases, who perhaps don't have a specific expertise in disability law, and we're able to help them. And you know, I want to mention a specific case that comes to mind, and this bleeds into the previous point about surveillance. I had a gentleman a few years ago who came to me, who was sent a 5-page denial letter from the insurance company with about 12 reasons of why they're denying the claim. This person was a high earner. There were mental health issues there. And part of the reasons for the denial was there was surveillance that was conducted. And of course, they said that there was insufficient medical documentation to support the disability. Within 7 months, we were able to resolve that claim for close to $300,000. Wow. Hello. And again, this is a person that was told you are not owed a cent. So again, don't simply assume, don't take at face value the denial from the insurance company. Don't assume you don't have a case.
You know, John, when I look at this email from Andrew, it strikes me as almost a perfect example of why you shouldn't appeal. And we talk about this every week on a radio show and on our television show. And some people hear us and some people don't. Some people think, well, you know, if I just appeal, maybe they'll understand. Yeah. No.
I'll be the guy.
No, the insurance company, in this case, has Andrew's wife's records from the family doctor, the rheumatologist, and a psychologist, all saying she can't work. And they know that CPP disability has approved, which is a tougher test. That is a tougher test to meet than most disability policies. They know already. They know what the score is. They're not going to change their mind. They're telling you that. There is no point in appealing. All you're going to do is prolong the resolution of your claim. Don't appeal. You start a legal claim as soon as possible.
Well, hold on. You may prolong the resolution, or you may simply walk away and get no resolution whatsoever.
That's true.
And that's what happens with a lot of people out there. And by the way, we have people calling us who have had claims more than 2 years ago. Remember, there is a 2-year limitation period from when you're first denied to start a claim. And they come to us, they were denied 3 years ago, and we can't do anything for them at this point. And they have left tens, if not hundreds of thousands of dollars in the insurance company's pocket. Money that's owed to them. So again, don't wait, don't assume that you have no rights. This is exactly what we're here for, to answer those questions and to help.
Coming up, putting a stop to your insurer's decision to stop LTD payments. That is on the way. Don't go anywhere. Stay with us. We'll be right back. Lots more In Your Corner is on the way.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to In Your Corner. You want to reach out anytime, 1-833-IN-YOUR-CORNER, inyourcorner.ca is the website, and help@inyourcorner.ca is the email address. Another resource for you to use anytime. We've been talking about this for years, and it's a really good one called mydisabilityquestions.com. You go there, you can leave comments, questions, and either Sivan, James, or a member of the team will answer them. There's a drop-down menu. There's a good chance that your question has been asked sometime in the last little while, so it's a good resource for that type of information. Want to get to one, though, that's fresh, and read this to you guys. I know you want to answer this one. James says, my friend was denied LTD, and her doctor at the rehab center she goes to said that he will help her appeal the denial. We love hearing that. She's 56 and had a stroke that caused her some paralysis and issues with focus and concentration. Should her doctor be doing this? Is there a risk in her appealing with his help?
Well, the appeal part of it, I think we've already dealt with several times on the show. You don't want to be appealing, regardless of who is helping you. The appeal isn't a step that you want to go towards. But putting that aside for a moment, I think the bigger issue here is the possibility that her doctor may be helping her with a aspect of her legal claim, and that's bad for a few reasons. The most obvious of which is your doctor does not have expertise in disability claims or the law, unless they went to law school and practiced for some period of time, and I doubt that's the case here. I tell virtually every single one of my clients, I'm not a doctor, I'm not going to give you medical advice. You listen to your doctor when it comes to that. You listen to me when it comes to legal advice, and the doctor should be saying the same thing, obviously, with respect to medicine.
Right.
So that's first and foremost. You don't go to your doctor to get legal advice or help. Another really big issue, and a very good reason why not to do this with a treating doctor, is because your doctor's opinion is something that you're going to be relying on in support of your claim. And if your doctor is not only providing you with a medical opinion, but is actively helping you with your legal claim, they're going to be seen as an advocate, and rightfully so. Their opinion isn't going to hold a lot of water anymore. And so, where they can help you, the medical side of it, they're not going to be trusted anymore, because people are going to see them and say, oh, well, they already have a stake in this. They're already invested in the outcome, so we can't really trust what they say.
Right. Got about a minute to go. Final thoughts, Sivan. What do you think?
Yeah, John, I want to talk directly to the audience, and I want to make sure people understand a concept that I think a lot of people are paralyzed by, which is fear. Insurance companies, when they're denying your claims, they're expecting you to be afraid to challenge them. Fear is a central component of their overall strategy. It's there when they're talking to you and telling you you have to go back to work when you're not ready. It's there when they're telling you you have to go to their doctors and do what their doctors say. It's there when they're telling you you have absolutely no way of qualifying for LTD because, frankly, there's just not enough medical documentation to support your claim. We see this day in and day out. I would say 90% of the people that we speak with are afraid in some way or another because they're disabled. You are disabled. You don't want to take on the insurance company. You want to try and get better. We help with that. We are the ones that will stand in the way between you and the insurance company.
Join us again right here on In Your Corner. You want to reach out? inyourcorner.ca.